when you think about this history of violence in Reconstruction era South, that there has to be a distinction between the experience of men and the experience of women. And we've talked about gender in the course and in this like latter section of the course in sort of high politics fashion about the split between abolitionists and suffrage. But what about on the ground? Is there like, what does a gendered history of Reconstruction look like?
That is a subject which is
enormous, among other things.
Well, I mean, it has gotten a lot of attention lately. When I was writing my book in the 1980s, there was very, very little work on that subject, but since then a lot has appeared. And most of it, not all by any means, but most of it is about African American women and how emancipation affected women sometimes in different ways than men, how the family was reconstituted in freedom, how becoming members of a family in freedom changes the dynamics within the family, because now you're under laws which assert the privilege of the man. The common law, the statute law, all insist that the man is the head of the family, and women basically are subsumed within that, and some women resented this, of course. The older idea, which some scholars have put forward both for North and South, that the experience of war itself helped to galvanize a kind of demand for greater rights among women, particularly white women, it doesn't seem to be emphasized very much anymore. Both Nina Silber and Drew Faust in their books on North and South argue that really women often wanted to go back to the more conventional gender roles that they had been pushed out of, so to speak, by the war. Although, of course, unlike in the South, the war does give rise to a very reinvigorated feminist movement and really is the launching pad which will lead 50 years later, it takes a long time, to the women's suffrage amendment. But there's a continuous history from the Civil War era now to women's suffrage. So certainly some women were galvanized to go in that direction. But I think, what's interesting also, as you mentioned before, the legal history of this era and what happens to the law of the family, the law of gender relations in the marketplace. Not that much at this moment. It will change slowly as the 19th century goes on. But, even the resilience of coverture is very remarkable. One case, Supreme Court case I didn't mention in the lecture, the Bradwell case, Bradwell v. Illinois, who was a woman who wanted to be a lawyer, Myra Bradwell, and when was barred from practice, Illinois state law barred women from practicing law. Only men could practice law. She went all the way up to the Supreme Court and said, this is a violation of the 14th Amendment, equal protection. I'm being denied my rights as a laborer, equal protection of the law. There's nothing in the 14th Amendment saying women aren't entitled to it. Supreme Court rejected her claim. They said, this is not law, this is nature. Women are just not suited to be lawyers. So this is not a discrimination. If you're just reenacting the law of nature, so to speak, you're not discriminating against anyone. So women are not capable of practicing law. Somebody reading the opinion said, well, men don't seem able to practice law properly either. If you read this decision, it's so illogical. But so the resilience of these older principles is very remarkable considering the radical changes that went on in this period.
But this raises the question of equal citizenship, which is something we talked about a lot in the course with relation to the 14th Amendment, which of course does enshrine birthright citizenship at the same time that it introduces these gendered exclusions into the document, much to the outrage of this feminist movement that is increasingly defining itself against this former abolitionist moment in this period. So does it make sense then, given this sort of simultaneous act of inclusion and exclusion, to think about the 14th Amendment as this brief for equal citizenship?
I believe it is, and I think many scholars, including friends of mine, I won't mention their name, misinterpret.
That might have gotten you in trouble recently.
Yeah, misinterpret the 14th Amendment. The inclusion of the word male is about one thing: voting, and representation for voting. Representation in Congress, and it is discriminatory, obviously, and the feminist movement was right to be outraged by introducing the word male into that section, but it does not have any bearing on the other section of equal protection. There is no gender difference in that. Privileged immunities, equal protection, those are for everybody. Now, of course, they're not implemented equally for everybody. Women are still subject, as we said, to the discriminations of statute law, common law, etc. And it takes a long, long, long time to eliminate that, and we still haven't totally 100%. But I think one has to distinguish these areas of equality. Voting is not, legally speaking, a right of citizenship. It is a privilege of citizenship. Not every citizen has the right to vote, yet that does not mean they are not a citizen. And at least under the 14th Amendment and under general discourse of the moment. So I'm not trying to claim that Thaddeus Stevens and Charles Sumner, well, Sumner would say he was a feminist, although the feminists were pretty annoyed at him for going back on his principles. But most radical Republicans in Congress were not feminists. They didn't think they were betraying anything. This is what they had tried to accomplish, equal rights for black people, and they didn't see a gender discrimination as undercutting that. But I think the critique of it by Stanton and Anthony and Woodhull and others was a very powerful critique and did lead. So I don't see the point of somehow, how should we put this, sort of choosing sides and saying, look how terrible the radicals were, or look how narrow-minded the women were. I think the point is to see the complexity of these issues at a moment of radical change.
On this issue of the 14th Amendment, though, it seems like for contemporary audiences, like the time that we hear about this is when the Supreme Court, under the guise of corporate personhood, is expanding corporate rights in some new direction. And this is something that happens a little bit after our course comes to a close. But how does this happen? This like transformation from the 14th Amendment into this like weapon for the rise of the corporation.
Well, you know, they say the Supreme Court reads the election returns, and the rise of the corporation was pretty hard to ignore. And throughout our history, going back to John Marshall, you know, the Supreme Court has always been very solicitous of economic development and not wanting to stand in the way.
You talked in class about this being like the force for conservatism built into the Constitution.
But is it conservatism? In this sense, they would say to themselves, no, we are actually we are looking for innovation.
The agents of this massive revolution.
Right. We don't want to put the court in the way of radical economic change, which is going on. The notion of corporations as persons was not invented by the Supreme Court. It's an old principle. The question is whether the 14th Amendment is meant to apply to them. Do they have the same rights as other kinds? There are certain, obviously, the whole idea of a corporation, among other things, is that the guys who are running it don't have to pay their bills. They don't have liability for, you know, the corporation has personal liability, not the directors and all this. But the court, you know, the Republican Party by the 1880s is more and more just intimately tied in with the interests of the largest corporations in the country. The Democratic Party is not much different. It may be dealing with some other different corporations, but this is the way politics is back then. The Senate is the, you know, chamber of millionaires, like it is today, actually. So one shouldn't maybe be surprised at how this influence exerts itself in politics. And similarly, one can blame the Supreme Court, as I do, seriously, for a series of horrible decisions vis-a-vis blacks in undercutting the Reconstruction amendments. And yet, if I had Justice White here, he'd probably say, hey, this is what people want. This is what voters want. We're just reflecting a general retreat. We're not inspiring the retreat. We're just reflecting what the general consensus in the North is about Reconstruction and black rights. People are no longer willing to go down that road. So what are we supposed to do?
But on the judge today, someone like Justice Scalia would say that, I mean, this is all about original intent, right? That you were just reconstructing what the framers, or in this case, what the people who were passing the 14th Amendment wanted.
There is not a scintilla of evidence, in my opinion, that anybody who was involved in drafting the 14th Amendment was thinking about corporations at all. This was not the issue in facing them. So I don't think original intent will get you very far when you are talking about corporate personhood and the 14th Amendment. But, you know, justices, even Scalia, who is a very coherent thinker, often contradict themselves. How can Scalia there's no way that Scalia actually, with his principals could defend Bush v. Gore decision. It was completely...
Well, he just doesn't want to talk about that.
Yeah, right, I know they don't, but they did...
You get a buy on that one, then you get a mulligan.
They did put a guy into the White House, so, that's not the way the court's supposed to operate, but nonetheless, they did it.